Good morning to all of you. Welcome to Legal Matters by Babbu Sukara. Jurisprudence class, part C. Question paper 2016. Somehow every question is taking minimum 10 minutes. Better to condense the time. I will try to reduce the time. Right. Question number 18. So the brief facts of the case are: the government intended to bring drastic changes in the penal provisions. Definitely, because crime is more, definitely some action has to be taken. After Nirbhaya amendment, no regulations have come. So the government intended to bring drastic changes in the penal provisions to control and check the crime rate in the society. For curbing the crime or to control the crime rate in the society, to reduce the crimes. So the government wants to bring drastic changes. As a part of the drastic change, the government imposed severe punishment even for simple hurt and petty offences also, beside the legality. So even for the simple offences, simple hurt, they are imposing, they wanted to give more penalty, and even for the petty offences also. Now we will discuss what are petty offences and what are the so-called simple hurt cases. So please remember. As far as the jurisprudence, now the issue is whether the government can impose severe punishments even for simple cases, simple offences. This is a question mark. Yes, definitely you can say no. In the yesterday already I told you in the question number 17, it should be rational. Punishment should be rational. Justice, equity and good conscience, these things should be there. What is equity? Yesterday I explained in question number 17. So if you want, you can refer to my previous video also. Now coming to this point, yes, definitely. So first of all, what is causing simple hurt? So they want to give major punishment for causing the simple hurt. So according to section 20, let us take 324, that's better. As whenever you hear the simple, the so-called simple hurt, better 324. 324 says voluntarily causing hurt with dangerous weapon or with dangerous means. So the imprisonment is for 3 years. Of course, it is cognizable. Sometimes due to the amendment of 2005, it is made non-bailable. So this is what is called simple hurt. What is hurt? So while the law of torts I told you, so a battery is called hurt. Hurt means whenever you use force intentionally. That is. So this is 3 years punishment. In some states it has been reduced to 2 years also. Right, just like our 354 IPC case. In Andhra Pradesh, 354 was punished up to 5 years, whereas the punishment is only for 3 years. So states can change. Now they want to enhance it. Then what is the petty offense? So petty offense means according to 206 CRPC. 206 CRPC deals with the so-called petty offense. Petty offense means an offense where more than 1,000 rupees fine cannot be imposed and where a person need not attend the court. So if in case the magistrate thinks that 206 thinks that there is no necessity for the attendance of the person to attend the court, yes, he may dispense with attendance. So this is called special summons in petty offences. So petty offence means any offence punishable not only with fine not exceeding 1,000 rupees, just now I told you, but does not include any offence or ME Act in the Radu, right? So no conviction will be given, only 1,000 rupees fine. In such a case, after taking cognizance of the offence, it can be disposed of summarily. So the accused person need not come to the court. When you receive the summons, simply if you say yes, I agree, and VT Koda, they want to enhance punishment. Is it reasonable? Is it justifiable or not? So this is what you have to think in the line of jurisprudence. So please remember, this is criminal jurisprudence, criminal justice system. So punishment, definitely it forms an essential part. So therefore we discussed about the analytical school, we discussed the utilitarian theory by Jeremy Bentham, that there should be some punishment, even though law should give more pleasure, but definitely there should be some punishment, right? Now punishment forms an essential part which is a form of the social condemnation of the crime. Yes, definitely. The person who committed the crime, if he is convicted, he will be condemned by the society. It is called the collective consciousness of the people. Now, according to HLA HART, HART versus Dworkin, remember it. HLA HART, there are certain essential elements of a punishment. There are rules. So, it should inflict some amount of pain and unpleasant consequences to the offender. Right? And as far as section 53 of the Indian Penal Code is concerned, it defines different types of punishment a person can be given, like death penalty, life imprisonment, rigorous imprisonment, simple imprisonment, forfeiture of property, as well as the fine. You already tell the fine, it is not defined anywhere how much fine has to be collected. It is a discretion of the judge. Now we have to discuss the different theories of punishment. You all know it is a deterrent theory, then retributive theory, preventive theory, reformative theory. At present, India does not want to be a police state. It wants to be a welfare state. Therefore, we are going to the so-called reformative system. Although India does not have a structured sentencing policy, the guidelines were not given by the legislature or judiciary, but Malimath Committee emphasized the need to introduce the sentencing guidelines. Of course, you know, the judges have got wide discretionary powers while awarding the sentences. You know, some judges are liberal and some judges are harsh. So, Malimath Committee advised a systematic sentencing procedure, right? So, for this, a committee should be formed under the chairmanship of the Supreme Court judge. So, please remember. So, if you want to give punishment, I will give you a couple of important cases. In the case of Soman versus Kerala 2012, here please remember, Supreme Court stated that this is a fit case to award death sentence because it is an illicit liquor case, spurious case, where so many persons died. Definitely enhanced punishment can be given. But please remember, in state of Madhya Pradesh versus Babbu Nath 2008, it is also a rape case. But the principle of awarding punishment should be taken like proportionality, deterrence, rehabilitation, personality analysis, and other things. That means, no doubt there are allegations of rape, but this man wanted to marry her. Then how long can you keep him in jail and make them depart? It's not a good procedure. So please remember. So no punishment can be said to attain a true purpose when it is disproportionate and it is unjust. This you have to know. Right? So likewise in section 304 IPC, you know the 304 part 1, that is unjust. 304 part 1, you know, suppose if any person culpable homicide not amounted to murder. So the punishment may be up to 10 years only. Yes, you should not enhance it to life. Likewise, just like we have discussed the case of 324 IPC. So best example is Sundar Singh and others versus the state 1954. In this case, please remember the punishment was awarded for 1 year. Yes, 3 years. Below 3 years they can give. But it should not exceed 3 years. That is what is stated. Likewise, in petty offences, already I discussed you according to section 6 RPC what is petty offence. In case of the so-called Rameshan versus State of Kerala 2010, this is a case of rash or negligent driving, booked under 279 IPC, read with ME Act 179. Of course, ME Act cases they do not fall under section 206 CRPC. But still, taking a lenient view, the court stated that after all it is a case where nobody was injured. So it can be taken as a petty offence. So please remember, to conclude, I want to tell you that the punishment should be proportionate to the crime, not excess. So basing on the excessive punishment, society will definitely not agree and they may revolt against the government also. To conclude, I want to tell you that the punishment should be proportionate to the crime. With this, I am concluding. Thank you very much.